Hey AP Government class, we still have a couple Supreme Court cases to go over. So today I'm going to start with Citizens United versus Federal Election Commission. So this was back in 2010. It revolved around the 2008 presidential election, which ended up being between President Obama and John McCain, but this actually reached back a little further to the Democratic primary process, where they were trying to figure out if Hillary Clinton or Barack Obama was going to be the presidential candidate for the Democratic Party. So the case involved a group called Citizens United. They were a conservative nonprofit corporation. They released a documentary called Hillary, the movie, in 2008. This was an election year, and Hillary Clinton was one of the leading Democratic candidates. This movie was very critical of Hillary and definitely cast her in a negative light. Citizens United wanted to release the film on demand for cable television so people could buy it, and they wanted to advertise the film in 3 commercials made for cable television. The problem is there was an existing law which stated that unions and corporations were groups that were not allowed any electioneering communications, and that included any broadcast, cable, or satellite communications that refers to a clearly identified candidate for federal office. Those communications can't be made within 60 days before a general election, meaning the presidential election, or 30 days before a primary election. And this specific release of the film was going to take place within 30 days of the Democratic primary elections. So the laws on the book also prohibited corporations or unions or associations from making any expenditure advocating the election or defeat of a candidate at any time. So they were not allowed to use their own funds in a way that would support any political candidate. The whole point of these laws was to try to limit the power of, well, your big corporations and your labor unions from just spending a bunch of money on candidates. The government didn't want candidates to win elections through money. So some laws such as the 2002 Bipartisan Campaign Reform Act, the whole point was to try to limit the spending power to make sure that elections would be won fairly rather than whoever could raise the most money. So the decision here, well, first of all, the key question was, did existing laws and court decisions preventing electioneering communications by corporations, associations, and labor unions with their own funds violate their First Amendment rights? And the ruling was very controversial to this day. The Supreme Court decided that political spending by corporations, associations, and labor unions is actually a form of protected speech under the First Amendment free speech clause. And they also expressed that silencing political beliefs of groups, such as those mentioned above, violates this concept of First Amendment freedom of association. The First Amendment does not mention freedom of association anywhere, but over the years it has come to be assumed that the First Amendment grants this, meaning you're allowed to meet with the groups that you choose and express your beliefs with the groups that you choose, as long as those beliefs don't advocate any violence or harm against other people. So in this case, freedom of association would be for corporations, associations, and labor unions to assemble and to express their political beliefs, which would be First Amendment freedom of speech and association. Also important is that the laws that were already on the books, including the Bipartisan Campaign Reform Act and the Federal Election Campaign Act, and 2 previous Supreme Court rulings, were essentially fully overturned or partially overturned. And this opened up big spending by groups called political action committees, which could raise funds from groups like corporations and labor unions. And now you have super PACs or super political action committees which raise millions of dollars and then mostly spend them on advertisements. So a lot of the advertisements that you see on TV now are actually funded by these groups as a result of this case. Next case we're going to look at is Baker versus Carr, 1961. So this case involved redistricting. So we had talked about gerrymandering and congressional district lines. When we talked about that, we were talking about congressional districts for the House of Representatives. So for example, in the state of Connecticut, we have 5 members in the House of Representatives who serve in DC. Therefore, we have 5 congressional districts. Only those people who live in the congressional district can vote for their representative. So for example, only the people who live in Eastern Connecticut, which is District 2, were allowed to vote and elect Joe Courtney as their House of Representatives member in the last election. The other 4/5 of Connecticut citizens didn't have any say in that choice. So that's just the concept of congressional districts, but that's at the national level. So what you have to understand is we also have congressional district lines for your state government, and there are many more congressional districts at the state level than there are at the national level. So we're looking at the state of Tennessee, and this case involved their state legislature district lines for their state government. And the guy who brought the case here, Charles Baker, who had been a mayor within Shelby County in Tennessee, he argued that there was a violation here of the 14th Amendment Equal Protection Clause because his particular state district had a population that was more than 10 times larger than some of the rural districts. They had not adjusted any district lines at the state level in Tennessee since 1901, so about 60 years had gone by. And we know, based on our studies, that today district lines are adjusted every 10 years due to the federal census. The census gets a adjusted population count as accurate as the nation can get it. So once the nation has that adjusted population count once every 10 years, they have to redraw district lines to make sure that the population of each congressional district is as close as possible. So Baker argued that this process hadn't been done in about 60 years, and districts were drastically different in size by this point, population-wise. And essentially what this does is if his district had 10 times as many people, yet they only have 1 representative, and then you have these rural districts that have far fewer people but also have 1 representative, you can argue that fewer people in these rural districts have more power than the many people in these larger population districts. So the questions here are, do legislative districts unequal in population violate the 14th Amendment Equal Protection Clause, saying everyone has equal protection under the laws? Are redistricting cases justiciable? I'm not sure if I'm pronouncing that correctly. You can look it up. Other words, this means, do federal courts have the power to exercise their authority over this issue? It's very similar to jurisdiction. So up until this point in history, the Supreme Court had not been involved in the redistricting process at all. This was viewed as a legislative process, not something that courts could look at. So the ruling, for the first time, the Supreme Court held that federal courts do have jurisdiction to consider any constitutional challenges to state legislative redistricting plans. So the court could decide whether districts were fair in terms of size and population, and before this was not really considered part of the court's jurisdiction. Based on this precedent, so this set an example here that the Supreme Court could hear cases about redistricting, and essentially what this case did is it opened a door for the court to go on to use that 14th Amendment Equal Protection Clause to make sure every person had equal treatment and protection under the laws, to develop this concept of 1 person, 1 vote, meaning every district, congressional district, either at the state level or at the national level, would have to be as equal as possible in population to make sure that every person's vote was considered equal. And it would also use this ruling to go on to prevent cases of gerrymandering, where even when you have one person, one vote, equal districts in size in terms of population, sometimes they would try to draw district lines that would concentrate many people of certain groups, let's say race, ethnicity, political party, into one district, or to separate them out so they couldn't, certain groups couldn't have political power. So because of this case, it led to the Supreme Court being able to have the power to prevent gerrymandering as well. Our next case is Shaw versus Reno, 1993. So this one also has to do with legislative redistricting lines, and this would be at the national level, not the state level, like with Baker versus Carr. So this case involved North Carolina. After the 1990 census, they came up with their reapportionment plan, and of the 12 districts in North Carolina, only one of them was what we call a majority minority district, in which there were more black voters than white voters. In the other 11 districts, there were more white voters. So the U.S. Attorney General at the time rejected North Carolina's congressional reapportionment plan because it did not create enough majority minority districts. As a result, the state of North Carolina had to submit a second plan. The second plan created 2 black majority districts. 5 North Carolina residents challenged the constitutionality of this plan, especially because if you look at the map here, at District 12 was one of the proposed new districts. That's the one in pink. You can see it's very oddly shaped. It's very thin. It stretched something like over 100 miles. And at some places, supposedly it was as wide as like the highway. So it was very clear to these residents that this district was created solely for the purpose of giving black voters more power in the state, and they thought that was an unconstitutional use of the Equal Protection Clause of the 14th Amendment. And it was actually an interesting case because it brought up this concept of reverse racism, where these residents, who were 5 white residents, felt that their constitutional rights as white Americans was being violated by this decision to redraw the districts in this way. So the key questions here were, did the North Carolina residents claim that the state created a racially gerrymandered district raise a valid constitutional issue under the 14th Amendment's Equal Protection Clause? So they argued that their rights were not being protected equally under the laws as white citizens. So the ruling was that the shape of the proposed district was so odd, when you look back at that pink district number 12, was so odd that there did seem to be no explanation for it other than to separate voters by their race. So the Supreme Court said that because this was the main factor here, it was not constitutional to solely draw district lines based on the race of the residents, because that would be akin to some kind of, you could almost say, like a segregation based on race. They also ruled that based on the Voting Rights Act of 1965, which made it very clear that the United States government had a responsibility to prevent discrimination in voting rights, the legislative redistricting process had to consider and be conscious of race when it drew these lines. But based on this decision, it made it clear that race can't be the main factor. You can't just draw a district in order to make sure that there's a certain number of people from a certain race. Other factors have to be present, and this can only be one of the factors, but not the main factor. Very importantly, the case signaled a shift away from using the Equal Protection Clause of the 14th Amendment to benefit African Americans. In this case, it actually worked against the political power of African Americans because instead of having those two majority-minority districts, the court ruled that this district was drawn in a way that it's going to have to go back to the original plan of one majority-minority district in North Carolina, unless they could come up with something that didn't seem as blatantly racially gerrymandered.